So it's Janet Gemmel again. Keep Your Family Law down here in Wilmington, North Carolina. I'm going to talk to you today about one of the issues in domestic violence. This is the first video of a series on how to file your own domestic violence action, or maybe just a little bit more information on the domestic violence action that you have with your attorney, or even if you're considering one in the future, or if you've had one in the past. I'm going to talk to you about those today. This video is for anyone not only who has had a domestic violence incident committed against them, but also even for the perpetrators. Everyone needs to understand how the process works, so let's jump in. Today is going to be about the first document that you'll need to fill out. It's called the summons. There is a form at nccourts.org or at your courthouse, and it's AOC CV-317. That is the civil summons for domestic violence. It actually is called Civil Summons Domestic Violence, not Domestic Violence Civil Summons. So if you're looking it up by its title, it's Civil Summons Domestic Violence. If you're looking it up by its form number, it's Form 317. Now, it's very interesting. Why do we have a special summons just for domestic violence when we have just a general summons for all other civil actions? That's because most civil actions you have 30 days to respond. Well, for domestic violence, you only have 10. So if you get served with a domestic violence action, or if you are serving one, know that the person who receives it only has 10 days from the date of service to answer that domestic violence complaint. A summons is issued once it's filled out, handed to the clerk, and clocked in. The good news in North Carolina, and really anywhere within the United States, is that domestic violence actions are free. They're free because of a federal law, the Violence Against Women Act. Okay? Doesn't matter if you're a male or a female filing in North Carolina, though, it is still free for you. So domestic violence actions in North Carolina are free to file. The summons is issued as soon as the clerk clocks it in. That's an issued summons. They put a date on it and it is ready to be served. Once you have completed your summons and it's been clocked in by the clerk, you have 5 days to send it out for service. In North Carolina, once you have the summons issued, you have to attach a number of other forms to that summons before you can send it out for service. And these are must attach, not shall or should. In North Carolina, you must attach a complaint. That's another form, and we'll get to that at a different video. You also must attach the notice of hearing. Again, another form in a different video. So you must also attach the ex parte order or any temporary orders the judge has issued. If, for example, that order was denied, you still have to attach it. And then any other documents which are necessary for service, that might be a specialized service issue in another state. Okay. In North Carolina, our sheriff, county to county, is allowed to serve. That's by personal service. They actually have to deliver it to the person directly or to someone in that person's household that is over 18 years of age and of a suitable discretion. That means they can't send it to somebody who's incompetent and just leave it with them. They actually have to leave it with somebody of suitable age and above 18. Now, there's other ways to serve in North Carolina. You can serve by registered mail, return receipt requested. Certified mail, return receipt requested. There's also another form of service by the Postal Service, and that's with signature confirmation. So either of those three methods through the post office. We also have in North Carolina a third way to serve, designated delivery service. If you send it by FedEx, then you have to obtain and request a delivery confirmation. That delivery confirmation can come back to you by fax or by email, but you still have to have that. Now, what happens if you're serving a minor? Well, you have to have a guardian ad litem to serve them. When would you ever serve a domestic violence action on a minor is probably something that you're asking. Sometimes parents have to serve domestic violence actions on their children, or you may have to serve one on a sibling or something like that. It happens more frequently than you could imagine. Sometimes grandparents are serving them on grandchildren. So there are just times when people will serve a minor, or even an incompetent person, somebody who may not be competent under law to manage their legal issues. Then you have to serve someone that's been appointed to represent their interest in court. That would be a guardian ad litem. If the person is outside the United States, that's going to be a whole nother topic that we are not going to cover in this video. But what happens if you don't know the person's address? Now remember that on the form, on the actual summons, you can put down a number of addresses. You can do a number of summons. You don't have to do just one. You can do a number of them as long as you have multiple copies. You should always have at least 2 white copies and 2 yellow copies. That's sort of my office rule of thumb for summons, even for domestic violence summons. But you can do as many as you want to. So for example, if you are a spouse and you're taking out a domestic violence action and you know where your husband or your wife works, or they're staying, maybe their girlfriend or boyfriend's house because it was a really bad breakup and that's why you guys are having some domestic violence issues, well, you can serve them in multiple locations, okay? So you can go to their work address. Maybe they work in 3 different places. You can do any of those. So you can add those in to give the sheriff, hopefully, the best means to serve that person. The best address for them is what you want to put on the summons. Now, what happens if you don't know the person's address? Well, then there's a process called service by publication. And that means that you'd have to publish for a number of weeks in a newspaper where the last place where they lived. It's a little bit more of a tricky process, which we're not going to go over today, but just know that if you don't know where they live, there's still an option for you, and that is service by publication. What happens if the sheriff has the document, they've had it out, they've tried to serve it, and it just didn't work? Are you out of luck because you know that they won't sign for a registered mail or certified mail and that they won't sign or get FedEx? What are you going to do? Well, here's the trick. Under North Carolina's law, what they've said is if your summons comes back undeliverable by the sheriff, then you can have an adult over the age of 21 or over, who's not related by blood or marriage and not a party to the action, serve them. That's great. You still have to try sheriff first. You still got to wait for that, but that's really a good deal, okay? Now, interestingly, remember that you have to serve a copy of the notice of hearing with the summons. And remember that most of these domestic violence actions happen within 10 days. So if you have a hearing within 10 days and you're having problems with process of service, ask the court to give you a hearing date at least 30 days out. Okay, keep your ex parte action in place. So you need a new ex parte order, and you're going to need to get a new notice of hearing. And then you're going to put all that together and send it back out for service. So generally speaking, we try to serve these pretty quick because there's some emergency relief and these are very large rights that are being affected. But sometimes somebody's hiding from service or you just don't know exactly where they are. Then you're going to serve by sheriff and you're going to ask the court for a little bit of additional time to get them served. And so that means you got to have the notice of hearing and everything else. Now, what happens if you can't get this summons served within 60 days? Because summons, if you think about them as a living, breathing document, they only live for 60 days without having some help. So if you can't get your summons served in 60 days, don't worry. There's still a process by which to extend the life of your summons. And what happens is that you can do one of 2 processes. The first is an endorsement, and you'll see the form. On the actual form, you'll see it down here. It says endorsement, okay? Or there's an alias and plurals, which is up here. Okay? So both of those have to be done within 90 days of the first issuance of the summons. So you have to do one or the other, and then you can continue to extend the life of the domestic violence action. If somebody harms you and then they flee the country, okay, you may need to extend the life of the alias and plurals summons until you can get them served. Or if they've just fled the state, they're hiding out, sometimes you have to extend the summons long enough to get them served. Okay, so here's the basic form. It's kind of what it looks like. Everybody sees it? Yay. You can go see it online, of course. You don't need me to show it to you. You put the name of the plaintiff and the address up here, the defendant, and all the other information. Okay, and then you take this to the clerk, and the clerk's going to issue it down here. Now, on the back is how we know that it has been served or what's been happening. So you're not going to be filling out anything on the back right away. That's going to go usually to the sheriff's office. I always say to my staff, the best way to serve is by sheriff. Don't worry about hurting someone's feelings. Worry more about not getting service. Service is important. You cannot proceed. No way cannot proceed. Court cannot do it. Judge cannot do it. They cannot hear from you until it's been served. Okay. Now you're going to probably have some ex parte relief, which means they've read the complaint. Maybe they've listened to you a little bit and they gave you an ex parte order. They can extend that order, but they can't hear anything else about it until that service has occurred. So it can be a little frustrating. When service takes time, don't give up. Hold tight, follow through. A little bit more information is that it is good to know that you can amend the summons or issue a new summons. Just remember you have to attach everything else that you've already attached. Again, the complaint, notice of hearing, any ex parte orders, any extension orders, all of that would have to be attached again. But let's say the person moves in the process of trying to serve them. You can amend your summons. So that's a pretty easy process. You just fill out a new one. Usually would do it alias employees or an endorsement. You can do that at any time as long as it's not prejudicial to the party. The other thing I would tell you is that sometimes people get a little confused about service. Here's what I mean. If you are the defendant, let's say that you are a husband who's been served with a domestic violence action, you've been removed from your home, and it tells you to go to court, and you don't go. What does that mean? And especially if you've been served by the sheriff, you have a copy, you know what the court date is. Court can proceed on the hearing date without you. They don't care. They don't care. So you need to answer within your 10 days. What happens if you've not been served, but your spouse is texting you telling you that you have to be to court and you show up? Well, you have two options. One is if you show up, you're technically showing that you have notice. The whole process of service is notice. And so arguably, they will just serve you there and give you a copy while you're there, and then you can ask for a continuance because you clearly haven't had your 10 days to answer. But remember, you only need 10 days to answer. The court is not likely to continue a domestic violence action much past that first initial 10 days because these are quick hearings. And they need to be heard as soon as possible because they're requesting emergency relief. Don't forget that in North Carolina, people still die every year from domestic violence. We treat it very seriously. So remember that you can also accept service. You can, if you hear that a domestic violence action has been filed against you, you can go down to the sheriff's office and ask them to accept it so they don't have to track you down. And you can usually sign on the back of the summons and accept service, or you can show up for court and let them serve you there or tell the judge that you accept service. This has been a service provided to you by Cape Fear Family Law and me, and I hope you have a great day. Thanks. Hit the like button and subscribe. Have a great day.